Before we begin, a quick and important disclaimer. The information presented in this video, as well as the subsequent installments of this 10-part series, is designed exclusively for educational, academic, and informational purposes. It does not, under any circumstances, constitute formal legal counsel, financial advising, psychological therapy, or professional consulting of any kind. Family law in the United States is inherently decentralized, governed primarily at the state level, rather than the federal level. This means that statutory provisions, the division of marital assets, custody presumptions, and spousal support calculations vary dramatically from California to New York, and from Texas to Florida. Because every individual situation involves distinct factual patterns, unique financial portfolios, and highly specific jurisdictional nuances, viewers must conduct their own due diligence and consult with a qualified, licensed family law attorney or professional financial advisor within their specific jurisdiction before making any legal, financial, or personal decisions. This material should be utilized strictly as a conceptual framework and not as a substitute for localized, professional legal representation. Every single year across the United States, an institutional shift occurs within hundreds of thousands of households, permanently reconfiguring the economic, social, and psychological fabric of American society. Sociological data compiled by the National Center for Health Statistics reveals a profound structural reality. Approximately 40 to 50% of first marriages in the U.S. ultimately trend toward dissolution, with that probability escalating significantly higher for subsequent marriages. Yet, despite the ubiquity of this phenomenon, the average citizen remains fundamentally misinformed about how the underlying mechanism actually functions. A pervasive misconception is that the process begins the moment an individual steps into a civil courtroom or signs a formal retainer agreement with a family law litigation firm. Historical trends and contemporary case studies reveal a much more complex, insidious reality. The ultimate trajectory of a marital dissolution is almost always predetermined long before any formal paperwork is filed, occurring during a silent, highly volatile phase that academic researchers classify as the period of emotional alienation and structural erosion. Consider the extensive case studies of dual-income households in suburban America, navigating the intersection of equitable distribution laws and the psychological toll of uncoupling. The decisions made during this pre-litigation phase, frequently driven by raw emotional reactivity rather than systematic, strategic analysis, regularly dictate the long-term socio-economic stability of both parties for decades to come. There exists a critical, often entirely hidden turning point within this initial phase that can completely alter the potential outcomes of asset division, parental rights, and post-divorce psychological recovery. Understanding this subtle inflection point is the fundamental difference between a cooperative, wealth-preserving transition and a protracted, financially catastrophic litigation battle that systematically depletes generational wealth and leaves deep emotional scars on all parties involved. The question is not merely how to survive the legal system, but how to comprehend the hidden structural forces that govern the entire life cycle of marital dissolution in the modern United States. To truly understand why this process is so complex, we must first examine the historical evolution of American family law. Prior to the late 1960s, the United States operated under a strict fault-based system. To secure a legal dissolution, one party was required to prove specific statutory wrongdoing by the other spouse, such as adultery, extreme cruelty, or willful abandonment. This created an adversarial framework deeply rooted in blame, often forcing couples to fabricate evidence or engage in public, highly destructive mudslinging, just to achieve a legal separation. This landscape shifted fundamentally in 1969 when California passed the Family Law Act, signed by then-Governor Ronald Reagan, which introduced the concept of no-fault divorce to the American legal system. By eliminating the requirement to prove marital misconduct, the state allowed couples to dissolve their union based solely on irreconcilable differences. This legislative domino effect swept across the country over the subsequent decades, fundamentally altering the power dynamics within American households. While no-fault systems lower the barrier to exit and provide vital safety valves for individuals in dysfunctional or abusive environments, they also introduce massive macroeconomic and sociological complexities. Today, we observe the unprecedented rise of the gray divorce phenomenon, a historical trend documented by researchers at the Pew Research Center showing that the dissolution rate among adults over the age of 50 has roughly doubled since the 1990s. This specific demographic faces unique, highly complex structural hurdles, as they are dividing mature retirement portfolios, navigating complex alimony structures after long-term marriages, and dealing with the stark realities of fixed incomes. The systemic impact of these shifts ripples through housing markets, social safety nets, and the transfer of generational wealth across the United States. For the contemporary United States audience observing, studying, or actively navigating this institutional landscape, the primary challenge is not a scarcity of information, but rather an overwhelming deluge of fragmented, highly polarized, and emotionally charged narratives. Individuals are frequently forced to rely on anecdotal advice from peers, sensationalized media depictions, or high-conflict online forums. This reliance on non-academic sources often leads to catastrophic legal missteps, operational paralysis, and severe cognitive overload. This comprehensive, multi-part academic discourse is designed to systematically resolve that exact problem. By synthesizing decades of empirical research from sociology, behavioral economics, and family jurisprudence, this series provides a highly structured, objective roadmap through the entire multidimensional life cycle of the American divorce journey. We are establishing the analytical foundation for this journey, moving entirely past emotional rhetoric to dissect the underlying mechanics of systemic decoupling. This masterclass serves to strip away the ambiguity, offering a clear-eyed examination of the predictable phases every individual moves through, whether they realize it or not. To achieve this, our series utilizes the foundational framework established by anthropologist Paul Bohannon, who famously conceptualized divorce not as a single legal event, but as a complex matrix of 6 overlapping stations: the emotional divorce, the legal divorce, the economic divorce, the coparental divorce, the community divorce, and the psychic divorce. Throughout this masterclass, we will explore how specific states categorize marital versus separate property, how federal tax codes influence the valuation of corporate benefits and real estate liquidations, and how the psychological phases of grief directly intersect with adversarial legal strategies. By understanding these patterns through the lens of historical data and established case studies, you gain the analytical capacity to view these circumstances not as an isolated, chaotic crisis, but as a recognizable, manageable institutional process. This framework empowers individuals to protect their psychological well-being, preserve their financial infrastructure, and minimize the systemic trauma inflicted on dependent children. Over the course of this deep dive, we will map out the hidden structural forces that govern custody evaluations, the economic realities of child support matrices, and the precise behavioral triggers that escalate legal costs. This is an objective academic analysis of a profound societal reality, offering the clarity and systemic insight required to successfully navigate one of the most complex legal and emotional landscapes in modern America. To understand the true genesis of this institutional transition, we must look past the courthouse steps and examine the first true station of Bohannon's matrix: the emotional divorce. This phase represents the long, often invisible runway of structural erosion and cognitive decoupling that occurs within the domestic sphere long before any legal mechanism is officially triggered. Academically, the emotional divorce is defined as the progressive deterioration of marital equity, characterized by a systematic withdrawal of psychological investment, the cessation of shared long-term planning, and the covert reestablishment of independent identities. It is an insidious process because it rarely happens symmetrically. Instead, historical trends and sociological case studies consistently demonstrate that one spouse almost always experiences this decoupling significantly ahead of the other, creating a profound structural imbalance that dictates the entire trajectory of the impending legal battle. Imagine a scenario unfolding in the current socio-economic landscape of 2026. Consider a professional named Marcus, a mid-level corporate director residing in a major metropolitan area in Ohio. To external observers, Marcus and his spouse appear to be navigating a standard, stable suburban marriage. However, beneath the surface, a process of silent cognitive decoupling has been underway for over 36 months. Marcus's spouse has already moved through the classical stages of grief associated with the death of a relationship: denial, anger, bargaining, and depression. By the time 2026 arrives, she has reached the final stage of acceptance. She has emotionally exited the marriage, processed the trauma of the dissolution, and begun viewing her life through the analytical lens of an independent individual. Marcus, meanwhile, remains completely oblivious, operating under the comforting illusion of a stable, if slightly distant, domestic routine. This reality introduces the critical academic concept known as the asymmetry of readiness. The asymmetry of readiness is arguably the single most influential predictor of high-conflict litigation, in the United States family law system. When the initiating spouse finally decides to formalize the separation, the non-initiating spouse is suddenly thrown into a state of acute psychological shock and intense denial. While the initiator is operating with a clear, calm, and highly organized cognitive focus, the receiver is forced to process profound trauma in real time. Case studies compiled by behavioral economists show that an individual in acute shock is statistically far more likely to make catastrophic strategic errors. They are driven by raw emotional reactivity rather than systematic, rational analysis. They may view early legal notices not as formal procedural requirements, but as personal declarations of war, leading to an immediate escalation of hostilities that drives up legal fees and obliterates any potential for a cooperative, wealth-preserving mediation process. This asymmetry is further compounded by broader sociological patterns regarding who actually pulls the legal trigger in America. Longitudinal data from institutions like Stanford University reveals a consistent historical trend. Approximately 69 to 70% of heterosexual divorces in the United States are initiated by women. In college-educated demographics, that figure escalates closer to 75%. Sociologists attribute this disparity to a variety of systemic factors, including shifting economic independence, changing societal expectations surrounding emotional labor, and localized institutional frameworks that offer specific protections for primary caregivers. When we look at this data through an educational lens, it becomes clear that the initiating party has typically spent months, if not years, quietly preparing for the operational realities of a post-divorce existence, while the other party has invested zero cognitive energy into preparing for a separate life. During this covert emotional phase, specific behavioral indicators of structural erosion begin to manifest within the household, even if they remain unacknowledged. Behavioral scientists often reference the foundational research of John Gottman, who identified specific communication patterns, namely criticism, contempt, defensiveness, and stonewalling, as highly accurate leading indicators of relationship dissolution. As these patterns solidify, the initiating partner often transitions into a phase of quiet documentation and strategic boundary setting. Without violating legal statutes or engaging in illicit surveillance, an individual who has emotionally checked out will naturally begin to segregating their personal identity. They start establishing separate social networks, opening independent bank accounts for post-separation expenses, and meticulously organizing financial records such as tax returns, mortgage statements, and corporate benefit structures. This period of quiet preparation can create a dangerous strategic trap when the emotional divorce finally collides with the financial reality of the household. In many case studies involving high-net-worth couples, an emotionally compromised spouse, upon discovering the impending dissolution, will react by engaging in sudden, desperate financial maneuvers. They might abruptly drain joint checking accounts, cancel shared credit cards, or attempt to hide marital assets in complex offshore accounts or digital currencies. From an educational and legal standpoint, these reactive actions are almost universally counterproductive. United States family courts operate under strict doctrines regarding the fiduciary duties owed between spouses during a marriage. Sudden, unilateral movements of capital are routinely flagged by forensic accountants and viewed unfavorably by family law judges under the legal doctrine of waste or the dissipation of marital assets. Instead of protecting the individual, these emotionally driven financial panics frequently result in severe judicial sanctions, the mandatory payment of the opposition's attorney fees, and an immediate loss of credibility before the court. This highlights why understanding the emotional phase is so vital. The psychological state of the parties directly governs their legal and financial conduct. If an individual cannot decouple their emotional grief from their operational decision-making, they will inevitably make choices that sabotage their own long-term socioeconomic stability. They become trapped in a destructive feedback loop where emotional pain drives aggressive legal tactics, which in turn causes financial depletion, escalating the emotional trauma even further. Furthermore, the emotional divorce phase sets the baseline for how the co-parental divorce will unfold if children are involved. When a couple enters the structural erosion phase, children often become unintended barometers for the domestic tension. Long before a formal custody petition is drafted or a guardian ad litem is appointed by a judge, behavioral patterns are established that will heavily influence future custody evaluations. For instance, if one parent begins withdrawing emotionally from the domestic unit, the other parent may naturally step in to absorb the surplus caregiving responsibilities. While this may seem like a natural adaptation to a failing marriage, It creates a historical pattern of caregiving that U.S. family courts weigh heavily when determining the best interests of the child standard. The status quo established during the dying days of a marriage frequently becomes the psychological and logistical foundation upon which permanent, legally binding custody schedules are constructed. As the quiet erosion of the marital bond reaches its absolute limit, the cognitive decoupling process transforms from an internal psychological state into an external, actionable reality. The initiating spouse reaches a point of absolute certainty where the perceived benefits of exiting the institutional framework outweigh the immense social, financial, and emotional costs of legal dissolution. The marital runway has completely run out. The hidden structural forces that have been operating entirely in secret within the walls of the suburban home are now poised to erupt into the public sphere, transitioning from a private psychological struggle into a matter of state record, binding statutory timelines, and adversarial legal proceedings. But what happens when this invisible emotional threshold is crossed and the first formal legal document is generated? How does the sudden, unexpected delivery of a divorce petition alter the neurobiology of the receiving spouse? And what are the immediate, legally binding automatic temporary restraining orders that lock down a couple's financial infrastructure the exact second a case is opened? In the next part of this deep dive masterclass, we will transition out of the psychological shadows and step directly into the high-stakes arena of the legal filing, breaking down the exact mechanics of how a civil action is initiated in the United States family court system, and how the very first 24 hours can irrevocably set the terms of your financial and personal future. The exact second a formal petition for dissolution of marriage is stamped by the clerk of the civil court, the entire structural reality of the marital unit shifts from a private domestic arrangement to an active litigation environment governed by rigid statutory mandates. This initial filing represents the official launch of the legal divorce, a phase characterized by precise procedural mechanics that leave zero margin for administrative error. In the United States family law framework, this process begins with the concurrent filing of two foundational instruments, the summons and the petition for dissolution of marriage. The petition serves as the formal pleading, detailing the jurisdictional facts of the marriage, including the exact dates of the union and the subsequent separation, the names and birth dates of any minor children, and the specific statutory grounds for the dissolution, which in the vast majority of contemporary cases is cited as irreconcilable differences. To establish jurisdiction, the filing party must meet strict residency requirements, which vary significantly across the United States. Historical trends indicate that jurisdictional conflicts often arise when spouses live in separate states or counties during the period of structural erosion. For instance, in the current landscape of 2026, a state like California requires at least one of the parties to have been a resident of the state for 6 continuous months and a resident of the specific county of filing for 3 months prior to submitting the petition. Failure to satisfy these precise durational residency thresholds results in an immediate dismissal of the action for lack of subject matter jurisdiction, forcing the parties to restart the administrative process from scratch and causing significant financial and strategic delays. Once the initial paperwork is processed by the court clerk, the constitutional requirement of due process dictates the next critical step, the service of process. This is the formal delivery of the summons and petition to the non-filing spouse, who is legally designated as the respondent. Case studies in family law dynamics emphasize that the manner in which service is executed can fundamentally dictate the emotional and tactical tone of the entire subsequent litigation. While some jurisdictions allow for service via certified mail or an acknowledgement of receipt signed voluntarily by the respondent, adversarial strategies frequently involve personal service executed by a licensed process server or a county sheriff. Imagine a scenario in 2026 involving a corporate executive named Amanda, residing in a high-density professional market like Northern Virginia. Amanda is completely unaware that her spouse has finalized the emotional divorce phase and retained a litigation firm. While entering her place of employment, she is publicly approached by a professional process server who hands her the legal documents. This precise moment triggers an immediate psychological and physiological crisis. The delivery of the summons strips away any lingering denial, instantly thrusting the respondent into an involuntary legal timeline. From the exact moment of personal service, a statutory countdown clock begins ticking. In most jurisdictions, the respondent is granted a strict window of 20 to 30 calendar days to file a formal, written response with the court. Failure to submit this response within the prescribed timeline allows the petitioner to move for a default judgment, a catastrophic procedural outcome where the court can potentially grant all of the petitioner's requested relief regarding asset division, child custody, and financial support without any evidentiary input from the respondent. However, the most profound and immediate legal consequence of the service of process is the instantaneous activation of automatic temporary restraining orders, commonly referred to as ATROs. Printed clearly on the reverse side of the family law summons in many jurisdictions, these are mutual, court-ordered injunctions that apply immediately to the petitioner upon filing and to the respondent upon service. It is critical to understand that ATROs are not criminal restraining orders designed to protect against physical violence. Rather, they are systemic financial and operational stabilization mechanisms designed to preserve the status quo of the marital estate and protect dependent minor children from unilateral parental disruption during the active litigation. Case studies involving high-conflict dissolutions routinely demonstrate the severe consequences that occur when an unrepresented or emotionally compromised individual fails to comprehend the absolute binding authority of ATROs. These orders systematically lock down the entire financial infrastructure of the household, imposing a strict fiduciary duty on both parties. Step by step, ATROs explicitly prohibit either spouse from transferring, concealing, encumbering, hypothecating, or disposing of any real or personal property, whether marital or separate, without the written consent of the other party or an explicit order from a family court judge. The only statutory exceptions carved out within these orders are transactions made in the ordinary course of business or for the generation of funds necessary to retain legal counsel and cover basic, non-discretionary living expenses. To illustrate the operational gravity of these orders, imagine if Amanda, in a state of acute panic following the service of the lawsuit, decides to log into her automated investment accounts to liquidate her joint cryptocurrency holdings and transfer those funds to a separate digital wallet under her exclusive control. Simultaneously, she contacts her corporate human resources department to remove her spouse from her employer-sponsored health insurance policy. Under the strict doctrines governing United States family law in 2026, both of these actions constitute direct, unambiguous violations of the standing ATROs. The removal of a spouse from an insurance policy, whether health, dental, vision, life, or automobile, is explicitly prohibited from the moment the case is initiated. The potential outcomes for violating these automatic restraining orders are exceptionally severe. When a party unilaterally alters the financial status quo, the aggrieved spouse's counsel will immediately file an emergency ex parte motion for sanctions and contempt of court. Family law judges view the breach of ATROs as a direct affront to the integrity of the judicial process. The court has the authority to issue evidentiary sanctions, which can prevent the violating party from introducing critical evidence at trial, order the immediate return of all liquidated assets, and mandate that the violating party pay 100% of the opposing party's attorney fees associated with rectifying the breach. Furthermore, under the legal theory of breach of fiduciary duty, the court can award a higher percentage of the disputed asset to the non-offending spouse as a direct punitive measure. Beyond the absolute freeze placed on financial portfolios, ATROs enforce critical structural boundaries regarding the custody and physical movement of minor children. The orders strictly prohibit either parent from removing the minor children of the marriage from the state of jurisdiction, or applying for a new or replacement passport for the children, without the prior written consent of the other parent or a specific court order. This prevents a high-conflict parent from engaging in a unilateral relocation strategy, an adverse tactical maneuver where one parent attempts to establish a new status quo residence with the children in a separate state to gain leverage in future custody determinations. The first 24 hours following the service of a divorce petition represent an operational minefield. The intersection of acute emotional trauma and complex statutory restrictions requires an individual to completely suppress behavioral reactivity in favor of disciplined, systemic compliance. The marital infrastructure is effectively placed into a state-mandated receivership. Every financial transaction, every communication, and every logistical choice regarding children is now subject to judicial scrutiny and retroactive evaluation. The activation of these automatic orders successfully stabilizes the marital estate, but it simultaneously creates an intense, pressure cooker environment. While the long-term division of assets and final custody arrangements remain months, if not years, in the distance, the immediate survival of the parties requires urgent, short-term stabilization. How do households navigate the immediate economic reality of paying mortgages, funding separate residences, and managing daily childcare when the existing domestic framework has completely shattered? In the next part of this deep dive masterclass, we will analyze the high-stakes world of temporary court orders and pendant light hearings, exploring exactly how family court judges rapidly allocate financial support and establish temporary custody matrices that frequently dictate the ultimate outcome of the entire legal journey. This operational stabilization is achieved primarily through the mechanism of temporary orders, known in legalese as pendant light relief, which translates literally to pending the litigation. The primary objective of the family court system during this volatile interim phase is to ensure that neither party is financially destitute, that the children of the marriage maintain a predictable level of environmental continuity, and that the marital assets are preserved until a final, comprehensive adjudication or global settlement can be reached. Because the full litigation process can routinely span 12 to 24 months, the court cannot allow a domestic vacuum to exist. Therefore, family law judges utilize expedited, short-term hearings to rapidly construct a temporary operational framework for the separated family unit. Imagine a scenario unfolding in the current socio-economic environment of 2026. Consider a software engineer named John, residing in a high-cost metropolitan area within Illinois. John provides the primary source of household income, while his spouse has scaled back her career over the past 7 years to manage the primary caregiving responsibilities for their 2 minor children. The moment the dissolution petition is served, the immediate logistical reality becomes overwhelming. John moves out of the marital home into a temporary apartment, creating an immediate financial strain. Without judicial intervention, a high-conflict environment could easily result in John withholding financial transfers to compel his spouse into accepting unfavorable terms, or conversely, his spouse denying him access to the children as a retaliatory measure. To prevent this type of strategic manipulation, either party can file a motion for pendant light relief. The procedural mechanism of the pendant light hearing relies heavily on the mandatory submission of comprehensive financial disclosures, typically referred to as an income and expense declaration or a financial affidavit. This document is signed under penalty of perjury and requires an exhaustive, line-by-line accounting of an individual's financial reality. Step by step, the individual must document their gross monthly income, tax filing status, mandatory deductions, and an itemized breakdown of regular living expenses, including housing, utilities, insurance, groceries, and outstanding consumer debt. In the rapid-fire environment of a temporary orders courtroom, judges rarely have the time to hear extensive oral testimony from witnesses. Instead, they rely almost exclusively on these financial affidavits, backed by recent pay stubs, corporate tax returns, and bank statements, to make immediate financial allocations. When determining temporary child support, U.S. family courts almost universally apply rigid, computerized statutory formulas. These automated state calculators utilize inputs such as the net disposable income of each parent and the exact percentage of physical timeshare each parent exercises with the children. Case studies across various jurisdictions demonstrate that at the temporary stage, courts prioritize mathematical uniformity over nuanced qualitative arguments. The calculator outputs a precise dollar figure that the higher-earning spouse must pay monthly to the primary caregiver. This temporary child support order is designed to cover the basic structural costs of raising the children, including housing, nutrition, and clothing, while separate add-on orders are typically generated to split the costs of unreimbursed medical expenses and work-related childcare proportionally based on income. Simultaneously, the court addresses the critical issue of temporary spousal support, often referred to as interim alimony. The underlying legal philosophy behind temporary spousal support differs fundamentally from the analysis used to determine permanent, long-term alimony. While permanent support requires a judge to weigh numerous statutory factors, such as the age of the parties, the marketable skills of the dependent spouse, and the overall length of the marriage, temporary spousal support is purely a tool to maintain the historical standard of living as closely as possible during the pendency of the litigation. Many jurisdictions utilize specific localized calculators, such as the Santa Clara Guideline or similar standardized formulas, to rapidly determine interim support. The potential outcome is a mandatory monthly transfer of wealth from the higher-earning spouse to the lower-earning spouse, effectively balancing the economic playing field while the case proceeds through the civil court system. However, the rapid allocation of funds represents only one half of the pendant light framework. The court must also construct a temporary custody matrix. This is where many unrepresented individuals fall victim to a psychological and legal phenomenon known as the status quo trap. When a couple separates, a temporary parenting schedule is often established casually or under intense emotional duress, just to manage the immediate crisis. A parent might agree to let the other spouse handle 80% of the parenting time for the first few months, operating under the assumption that this arrangement is merely a temporary accommodation that will not impact the final custody determination. Historical trends in family jurisprudence reveal a starkly different reality. Family court judges are heavily bound by the best interests of the child standard, an analytical framework that prioritizes psychological stability, environmental continuity, and the minimization of disruption in a child's life. If a temporary parenting schedule remains in place for 6, 9, or 12 months while the litigation progresses, that schedule effectively solidifies into the child's new established status quo. When the case finally reaches a trial judge for a permanent custody determination, the court will look very unfavorably on any proposal to drastically alter a schedule that has proven to be stable and functional during the interim period. Thus, the temporary arrangements made in the first few weeks of a separation regularly dictate the permanent legal rights of parents for the remainder of their children's minorities. Furthermore, the pendant light hearing is the forum where the court determines the exclusive use and possession of the marital residence. If both parties refuse to vacate the family home, creating a highly toxic or potentially unsafe environment for the children, the judge must make a difficult logistical decision. The court will evaluate which parent is best positioned to maintain the household, the proximity of the residence to the children's schools, and the financial feasibility of requiring one spouse to secure alternative housing. The parent who is granted exclusive possession remains in the home, while the vacating parent is legally barred from re-entering the property without express permission, regardless of whose name is on the deed or the mortgage note. The judge will then allocate the responsibility for servicing the mortgage, property taxes, and utility bills, often ordering the higher earner to pay these operational costs directly to the service providers as a component of their overall support obligation. Finally, to ensure that a wealthier spouse cannot use their financial superiority to starve the less-moneyed spouse out of the legal system, family courts frequently issue need-based interim attorney fee awards. Under historical trends in U.S. family law, judges have the statutory authority to order one party to pay a reasonable advancement toward the other party's legal fees and expert witness costs. This mechanism ensures that both individuals have access to competent legal representation, preventing one side from drowning the other in excessive motion practice or forced capitulation due to a complete lack of liquid capital. The conclusion of the pendant light phase establishes a rigid, court-enforced scaffolding around the fractured family unit. The finances are locked down, the support checks are automated, the parenting schedule is formalized, and the living arrangements are legally mandated. While this brings a degree of predictability to the daily chaos of separation, it simultaneously signals the transition into the most invasive, exhaustive, and strategically complex phase of the entire legal divorce journey. With the temporary baseline firmly secured, both legal teams now turn their full attention toward uncovering the absolute, unvarnished truth of the marital estate. How do forensic accountants systematically track down hidden assets, offshore accounts, and undervalued business entities that one spouse may have spent years trying to conceal? What happens when a party is forced to sit for hours under oath in a court reporter's office, answering highly intrusive questions about their personal and financial conduct? In the next part of this deep dive masterclass, we will step directly into the high-retention, high-stakes world of formal discovery and depositions, mapping out the precise mechanisms used to strip away financial secrecy and lay bare the true value of the marital empire. The formal discovery phase represents the investigative engine of the entire litigation process, governed strictly by state rules of civil procedure. Once the temporary scaffolding of pendant light orders is erected, the legal framework shifts from immediate crisis management to a systematic, information-gathering campaign. Discovery is the mandatory, structured exchange of information, documents, and under-oath testimony between the competing parties. The foundational philosophy of modern United States family law rejects the notion of trial by ambush. Instead, the statutory framework is engineered to ensure that both sides possess equal access to all relevant facts, financial records, and operational realities of the marital estate before entering into final settlement negotiations or presenting evidence before a family court judge. To execute this investigative process, litigation teams utilize a highly specific toolkit of written discovery instruments, each designed to extract distinct types of data and narrow the scope of the legal dispute. The first tool in this sequence is interrogatories, These are formal, written questions drafted by one party and served upon the other, requiring written answers that must be verified under penalty of perjury. Interrogatories are typically bifurcated into form interrogatories, which utilize standardized, court-approved questions regarding basic background information, employment history, and general asset lists, and special interrogatories, which are customized, highly targeted questions crafted to probe specific vulnerabilities, such as unrecorded cash transactions, undisclosed business partnerships, or the precise timelines of alleged marital misconduct. The second critical instrument is the request for admission. This tool requires the receiving party to either admit or deny the truth of a specific statement or the authenticity of a particular document within a strict statutory timeframe, typically 30 days. Requests for admission are highly strategic because any matter admitted under this mechanism is treated as conclusively established for the remainder of the litigation, eliminating the need to spend valuable time and financial resources proving that specific fact at trial. If a party fails to respond to these requests within the prescribed window, the court may deem all statements admitted, a procedural outcome that can completely undermine a party's legal position. The most logistically exhaustive component of written discovery is the request for production of documents. This mechanism demands that a party locate, organize, and deliver physical or digital copies of every record relevant to the financial and personal history of the marriage. In the contemporary legal landscape of 2026, the parameters of document production have expanded exponentially due to the ubiquity of digital footprints. Litigation teams no longer merely request traditional paper bank statements and physical tax returns. Modern requests for production encompass a vast array of electronic data, including native Excel spreadsheets with intact formulas, complete metadata from personal computers, cloud storage archives, encrypted messaging application logs, and historical transaction ledgers from peer-to-peer payment platforms and decentralized digital asset wallets. Imagine a scenario unfolding in 2026 to illustrate how these written discovery tools function in a high-stakes corporate environment. Consider a case study involving a business executive named Sarah and her spouse, Robert, who operates a privately held logistics and consulting enterprise. Throughout the period of structural erosion, Robert has consistently claimed that his business has suffered severe financial reversals due to shifting global macroeconomic conditions in 2026, asserting that corporate revenues have plummeted by over 50%. Consequently, Robert argues that his capability to pay spousal support is virtually non-existent, and that the valuation of his business entity is minimal. Faced with this assertion, Sarah's legal counsel initiates a comprehensive discovery sequence. They serve Robert with extensive requests for production, demanding 5 years of general ledgers, corporate tax returns, bank statements for all operating and payroll accounts, accounts receivable logs, and independent auditor reports. To analyze this massive influx of financial data, Sarah's team retains a certified forensic accountant. Forensic accounting in modern family law relies on systematic data reconstruction rather than taking financial statements at face value. The forensic accountant initiates a comprehensive lifestyle analysis, which is a step-by-step auditing process that calculates the total amount of capital required to maintain Robert's actual, real-world standard of living. If the lifestyle analysis reveals that Robert is consistently funding luxury vehicle leases, high-end travel, and country club memberships while simultaneously reporting a net personal income that cannot mathematically support those expenditures, the forensic accountant flags a systemic discrepancy. The accountant will look for common methods of financial concealment, such as the deliberate deferral of corporate distributions, the inflation of business expenses through the payment of non-existent consultants, or the manipulation of accounts receivable where invoicing is intentionally delayed until after the finalization of the divorce. When a party attempts to obstruct this investigative process by providing incomplete records or claiming that the requested documents no longer exist, the family law framework provides a powerful countermechanism, the subpoena duces tecum. This is a court-issued mandate served directly onto third-party institutions, such as commercial banks, mortgage lenders, credit card corporations, and corporate clients. Because the subpoena carries the absolute authority of the court, the third-party institution is legally compelled to produce the unedited financial records directly to the requesting attorney's office, completely bypassing the uncooperative spouse and stripping away any capacity for data manipulation. Once the documentary foundation is firmly secured through written discovery and third-party subpoenas, the litigation transitions to its absolute tactical climax, the oral deposition. A deposition is a formal out-of-court proceeding where a party or witness is placed under oath and subjected to direct, live cross-examination by the opposing counsel. The entire proceeding is recorded verbatim by a licensed court reporter who generates an official transcript, and in modern 2026 litigation, these sessions are routinely video recorded to capture behavioral tells, pauses, and physical demeanor. The primary objective of a deposition is twofold: to discover hidden information and to freeze the witness's testimony. During a deposition, an attorney will systematically walk the spouse through their financial disclosures, business operations, and personal assertions. Because the witness is under oath, any false statement made during a deposition carries the exact same legal penalties as lying on the witness stand in an open courtroom, including potential criminal charges for perjury. Furthermore, the deposition transcript serves as an absolute safeguard against shifting narratives. If a spouse attempts to alter their story during a subsequent trial, the opposing attorney will immediately utilize the deposition transcript to impeach their credibility, presenting the judge with the exact contradictory statement made under oath months prior. Historical trends in family law demonstrate that once a party's credibility is comprehensively compromised during a deposition, their ability to secure favorable potential outcomes at trial diminishes catastrophically. The completion of the formal discovery phase effectively strips away the veil of financial anonymity, laying bare the absolute, empirical truth of the marital infrastructure. Every bank account has been audited, every corporate ledger has been scrutinized, and both parties' testimonies have been locked into permanent record. The case has reached its point of maximum informational clarity. However, uncovering the raw data is merely the preliminary step. The legal system must now apply complex, highly contested valuation methodologies to this data to determine exactly how the accumulated wealth will be permanently divided under the laws of the jurisdiction. How do states differentiate between community property and equitable distribution? And what are the precise mathematical formulas used to value a closely held corporation or trace separate property funds that have been aggressively commingled with marital wealth over a 20-year marriage? In the next part of this deep dive masterclass, we will enter the highly technical world of characterization and valuation, analyzing exactly how the state dismantles and distributes the financial empire of the modern American family. The allocation and division of marital wealth within the United States family law framework relies on a highly technical, two-tiered analytical process: characterization followed by valuation. Before a family court judge can assign a single asset to either spouse, the court must first determine the legal identity of every piece of property owned by the parties. The United States is fundamentally divided into two distinct legal systems regarding property division. The majority of states operate under the doctrine of equitable distribution, which mandates that all property acquired during the marriage be divided fairly and equitably, though not necessarily in a mathematically equal 50-50 split. Conversely, a significant minority of states, including highly populated jurisdictions like California, Texas, and Washington, strictly adhere to the community property framework. In these jurisdictions, the statutory baseline dictates an absolute, mandatory 50-50 division of all community assets and debts, accumulated from the date of marriage to the date of separation. Under both systems, the legal presumption dictates that any asset acquired by either spouse during the marriage is marital or community property. Rebutting this legal presumption requires the contesting party to produce clear and convincing documentary evidence demonstrating that the asset is separate property. Generally, separate property is defined as anything owned prior to the marriage, or acquired during the marriage via an individual inheritance or a personalized third-party gift. However, over the course of a long-term marriage, the boundaries between separate and marital property routinely dissolve through a complex financial process known as commingling. Commingling occurs when separate property funds are mixed with marital funds inside a shared financial environment, such as a joint bank account or an active investment portfolio. When these funds are used over many years to pay for shared living expenses, service mortgages, or purchase new assets, the original separate identity of the capital becomes obscured. To reclaim this separate property equity, family law litigation teams rely on forensic accounting to execute asset tracing. There are two primary methodologies accepted by United States courts for tracing commingled funds: the direct tracing method and the exhaustion method. The direct tracing method requires a step-by-step audit of every ledger entry. The forensic accountant must prove that separate funds were deposited into the commingled account, that those specific separate funds remained continuously available in the account, and that the party explicitly intended to use those specific separate funds to purchase a particular asset. The exhaustion method, on the other hand, requires proving that at the exact moment a specific asset was purchased, all available community or marital funds in the joint account had already been completely exhausted by family expenses. If the marital funds were at zero, any remaining capital used for the purchase must mathematically have been the separate property of the contributing spouse. If the forensic accountant cannot definitively satisfy the evidentiary requirements of either method due to incomplete bank records, the court will rule that the separate property has been hopelessly transmuted into marital property, resulting in its equal division. To observe how these concepts collide with corporate entities in the current economic landscape of 2026, consider a case study involving a business founder named David and his spouse, Emily. In 2022, prior to his marriage to Emily, David established a closely held enterprise cloud computing consultancy. At the date of their marriage, the business was a small operation with a verified valuation of $200,000. By the current year of 2026, the corporation has experienced massive growth, achieving a market valuation of $5 million. Although the business entity itself was indisputably David's separate property at the date of marriage, the $4,800,000 increase in value occurred entirely during the timeline of the marriage. This scenario introduces one of the most heavily litigated dilemmas in family law: the apportionment of business appreciation. United States courts utilize two primary landmark legal doctrines to resolve this specific issue, known historically as the Pereira analysis and the Van Camp analysis. The selection of which formula to apply depends entirely on what primary driver caused the business to grow. The Pereira analysis is deployed when the appreciation of the separate property business is primarily attributed to the personal skills, hard work, and unique expertise of the operating spouse. Under the Pereira formula, the court calculates a reasonable rate of return on the original separate property value of the business, wraps that interest back into the operating spouse's separate property column, and characterizes the entire remaining balance of the appreciation as marital or community property, because it was generated by the marital labor of the spouse. Conversely, the Van Camp analysis is utilized when the growth of the business is primarily driven by external macroeconomic factors, market forces, corporate branding, or substantial third-party capital investment, rather than the daily efforts of the founder. Under the Van Camp formula, the court determines the reasonable market value of the operating spouse's services over the years of the marriage, subtracts the actual compensation and benefits the spouse already drew from the company, and allocates any undercompensated amount to the marital estate, while the vast majority of the massive business appreciation remains the separate property of the original owner. In the case of David and Emily in 2026, millions of dollars hang on the forensic determination of whether the enterprise software market's natural growth or David's personal engineering labor was the true catalyst for the company's expansion. Once the characterization of a business entity is established, the litigation team must execute a comprehensive valuation of the corporation, a process that moves far beyond basic accounting software inputs. For closely held businesses where shares are not publicly traded on a stock exchange, valuation experts utilize three main academic approaches: the asset-based approach, the market approach, and the income approach. The asset-based approach calculates the net value of the company by subtracting total liabilities from the current market value of all tangible and intangible corporate assets. The market approach looks at historical trends and analyzes recent sales of comparable businesses within the same industry sector. The income approach, frequently executed via a discounted cash flow analysis, forecasts the future economic benefits the business will generate and discounts them back to present value dollars using a risk-adjusted capitalization rate. The most intensely contested element within this valuation process is the calculation of enterprise goodwill versus personal goodwill. Goodwill represents the intangible value of a business driven by its reputation, customer loyalty, and market position, which allows the company to generate profits exceeding the normal return on its tangible assets. Family law frameworks across the United States draw a sharp, legally binding distinction between these two categories. Enterprise goodwill is the intangible value that adheres to the corporate entity itself, independent of who owns or operates it. This form of goodwill is considered a marital asset subject to valuation and distribution. Personal goodwill, however, is the intangible value tied directly to the individual reputation, unique talent, and personal relationships of the founder. Because personal goodwill cannot be sold or transferred to a third party without the founder remaining at the company, many state jurisdictions exclude it from the marital estate entirely, classifying it instead as future earning capacity. The resolution of these complex characterization and valuation battles effectively locks in the total net worth of the marital estate. Every real estate holding, corporate entity, and commingled financial account has been assigned a definitive dollar value and characterized as either separate or shared property. But once this definitive valuation is secured, a massive structural problem emerges. How does a couple actually execute the physical separation and transfer of these multi-million-dollar asset portfolios without triggering catastrophic tax events, massive liquidation fees, or the immediate collapse of operational business entities? In the next part of this deep dive masterclass, we will shift out of the courtroom valuation phase and enter the intricate, high-stakes world of the economic divorce, exploring the specialized legal instruments used to split corporate retirement plans, navigate federal tax liabilities, and manage the liquidation of primary marital residences in the modern American economy. The execution of the economic divorce demands an uncompromising transition from theoretical valuation to structural liquidation and asset reassignment. Once the final characterization of the marital estate is determined, the legal teams must implement specialized legal and financial instruments to physically untangle the wealth without triggering catastrophic tax consequences or operational disruptions. This process is particularly arduous when dealing with retirement infrastructure and corporate benefit packages. Qualified retirement plans such as a corporate 401k or a traditional defined benefit pension plan are strictly governed by federal law under the Employee Retirement Income Security Act of 1974, commonly known as ERISA. Because these plans are protected by stringent federal anti-alienation provisions, a state family court judge lacks the unilateral authority to order a corporate plan administrator to distribute a portion of an account to a non-employee spouse. To circumvent this federal barrier, the legal system utilizes a highly specialized, separate legal instrument known as a Qualified Domestic Relations Order, or QDRO. The drafting of a QDRO is a meticulous procedural sequence that occurs entirely parallel to the standard divorce litigation. The order must be custom-tailored to the specific administrative guidelines of the target retirement plan. Step by step, the document must state the exact name and last known mailing address of the participant and the alternate payee, the precise dollar amount or percentage of the participant's benefits to be paid to the alternate payee, and the exact number of payments or the specific period to which the order applies. Case studies in family law administrative failures demonstrate that if a QDRO contains ambiguous language regarding the calculation of market gains and losses during the litigation period, or if it erroneously attempts to provide a type or form of benefit not otherwise available under the plan, the corporate plan administrator will reject the order entirely. This forces the parties to return to the drafting stage, accumulating significant extra legal fees and delaying the distribution of capital for months. Once a QDRO is successfully approved by the plan administrator and subsequently signed by the family court judge, the alternate payee can execute a tax-free rollover of their allocated funds into an individual retirement account, thereby preserving the tax-deferred status of the wealth and avoiding the standard 10% early withdrawal penalty. To observe how these complex economic mechanisms function within a modern corporate context, imagine a 2026 case study involving a corporate executive named Michael and his spouse, Jessica, residing in a high-growth technology corridor like Austin, Texas. Throughout their 14-year marriage, Michael accumulated a significant corporate 401k portfolio, along with an extensive array of unvested restricted stock units, commonly referred to as RSUs, granted by his employer as long-term incentive compensation. While the 401k can be systematically divided using the QDRO framework, the unvested RSUs present a far more volatile valuation and distribution challenge. Because these stock units have not yet met their temporal or performance-based vesting conditions in 2026, they represent a contingent future right, rather than immediate liquid wealth. To allocate this asset equitably, family law courts across the United States routinely rely on historical trends and established judicial formulas, most notably the time rule formula. This mechanism constructs a specific fraction to determine the community or marital property percentage of each stock grant. The numerator of the fraction consists of the total number of months from the original date of the stock grant to the precise date of the legal separation of the parties. The denominator consists of the total number of months from the original date of the stock grant to the ultimate date of the vesting of the shares. The resulting percentage defines the marital portion of the equity, which is then divided equally or equitably between the spouses. Jessica's legal counsel ensures that the final judgment contains a constructive trust provision, legally compelling Michael to hold her calculated percentage of the shares under a strict fiduciary duty, and deliver the net cash proceeds to her immediately upon each future vesting date. Beyond corporate equity and retirement portfolios, the overarching framework governing the economic divorce is anchored directly to the Internal Revenue Code, specifically Section 1041. This critical federal statute establishes the non-recognition rule, dictating that transfers of property between spouses, or between former spouses if the transfer is incident to the divorce, do not trigger an immediate income tax, capital gains tax, or gift tax liability. The law treats these reassignments as non-taxable, carryover basis events. This means that the spouse receiving an asset steps into the exact financial shoes of the transferring spouse, inheriting the asset's original historical cost basis along with any embedded, deferred tax liabilities. This introduces a pervasive structural trap that forensic accountants must meticulously analyze during settlement negotiations. If Jessica receives the primary marital residence with a superficial equity value of $1 million, but an exceptionally low historical cost basis, while Michael receives an equivalent $1 million in clean, liquid cash from a joint high-yield savings account, the division appears perfectly equal on a standard balance sheet. However, historical trends in post-divorce liquidation show that when Jessica eventually sells the real estate years down the road, she will absorb the full brunt of the deferred capital gains tax on the appreciation, severely diminishing her true net potential outcomes and revealing that the initial division was fundamentally inequitable. This reality leads directly to the complex mechanics of managing the primary marital residence under Section 121 of the Internal Revenue Code. For the vast majority of American households in 2026, the equity locked within the primary home constitutes their single largest financial asset. Under standard federal tax laws, an individual can exclude up to $250,000 of capital gains from their taxable income upon the sale of their principal home, while a married couple filing jointly can exclude up to $500,000. To qualify for this substantial tax benefit, the owners must satisfy the ownership and use tests, meaning they must have owned and occupied the property as their principal residence for an aggregate of 2 out of the 5 years preceding the exact date of sale. Imagine a scenario where Michael permanently vacates the marital residence during the early pendant light phase to de-escalate domestic conflict, while Jessica continues to reside in the property during 3 long years of protracted litigation. If the property is eventually ordered sold at the conclusion of the divorce, Michael could technically fail the physical occupancy test because he has not lived in the home for 2 out of the past 5 years. To prevent this inequitable tax burden, skilled family law practitioners utilize specific statutory safe harbors carved out within Section 121(d)(3). This provision explicitly states that if an individual is granted the right to use the property under a formal divorce or separation instrument, the other spouse's subsequent use and occupancy of the home is legally imputed to the non-residing spouse. This strategic maneuver preserves Michael's capability to claim his full $250,000 individual capital gains tax exclusion upon the eventual liquidation of the property, protecting hundreds of thousands of dollars in generational wealth from unnecessary taxation. The successful navigation of the economic divorce provides the parties with a definitive, highly structured financial separation, drawing a permanent line between their respective post-divorce estates. The corporate retirement plans are successfully bifurcated via QDROs, the unvested equity is bound by time rule formulas, and the primary residence is liquidated or transferred with meticulous adherence to federal tax codes. However, for couples with minor children, the resolution of the financial empire merely clears the stage for the most profoundly complex, emotionally exhausting, and heavily scrutinized phase of the entire institutional journey. The focus shifts entirely away from corporate balance sheets and cost basis calculations to center on the psychological, emotional, and physical well-being of the next generation. How do family courts transition from dividing passive financial capital to allocating the rights and responsibilities of raising human beings under the absolute authority of the state? What occurs when the legal system deploys state-appointed forensic psychologists, child custody evaluators, and guardians ad litem to conduct exhaustive, invasive investigations into the daily parenting capabilities and moral fitness of each individual? In the next part of this deep dive masterclass, we will cross the threshold into the high-stakes arena of the coparental divorce, analyzing the precise operational mechanisms used to determine legal custody, establish physical parenting schedules, and calculate child support obligations through the lens of modern behavioral science and statutory family jurisprudence. The allocation of parental rights and responsibilities constitutes the coparental divorce, a phase where the family law system transitions from the mathematical distribution of passive capital to the profound task of regulating human relationships. In the United States jurisprudence, this phase is governed by two entirely distinct legal concepts that individuals frequently conflate: legal custody and physical custody. Legal custody refers to the absolute statutory right and operational responsibility to make major, long-term decisions regarding a minor child's upbringing, specifically centering on three core domains: education, non-emergency healthcare, and religious development. The historical trend across the United States heavily favors joint legal custody, a baseline presumption where both parents must actively consult with one another and reach a mutual consensus before enrolling a child in a specific school, selecting a medical specialist, or initiating a major elective medical procedure. If one parent acts unilaterally in these domains without the consent of the co-parent, they commit a direct violation of the court order, exposing themselves to contempt of court proceedings. Sole legal custody is rarely granted, reserved almost exclusively for extreme case studies involving chronic substance abuse, unmanaged severe mental illness, domestic violence, or total parental abandonment. Physical custody, conversely, dictates the actual real-world living arrangements and the day-to-day physical care of the children. This can range from sole physical custody with scheduled visitation to a true 50-50 joint physical custody framework. When parents cannot reach a voluntary agreement on a parenting schedule, the state family court steps in to adjudicate the dispute based on the best interests of the child standard. This analytical framework is intentionally broad, requiring judges to weigh an array of statutory factors. These factors include the historical role each parent has played as the primary caregiver, the emotional stability and moral fitness of each individual, the co-parent's demonstrated capacity to facilitate a continuous, meaningful relationship between the child and the other parent, and the child's existing ties to their school, neighborhood, and extended support network. To understand how this high-stakes adjudication functions in the current legal landscape of 2026, imagine a scenario involving a healthcare administrator named Christopher, residing in a highly competitive professional market within Michigan. Christopher is locked in an intense dispute with his co-parent over the physical custody schedule of their two elementary-age children. Christopher is advocating for a true joint physical custody arrangement, operating on an alternating week-on, week-off schedule. His co-parent, however, asserts that Christopher's demanding hospital shift rotations and frequent on-call duties create an erratic domestic environment that is fundamentally incompatible with the children's academic and emotional stability, demanding instead that she be granted sole physical custody with Christopher limited to alternating weekend visitation. Because Christopher and his co-parent are completely deadlocked, the family court judge appoints a neutral forensic psychologist to conduct a comprehensive child custody evaluation. This process represents an exceptionally invasive, step-by-step psychological and behavioral audit of the family unit. The evaluator begins by conducting exhaustive clinical interviews with both Christopher and his co-parent, tracing their personal histories, parenting philosophies, and perceptions of the children's developmental needs. To identify any underlying personality disorders, emotional volatility, or defensive responding patterns, the evaluator administers standardized psychological testing, most commonly the Minnesota Multiphasic Personality Inventory. Following the individual assessments, the evaluator conducts structured home observations, entering both Christopher's apartment and his co-parent's residence while the children are present. During these site visits, the forensic psychologist meticulously documents behavioral cues, assessing parental warmth, the efficacy of disciplinary boundaries, the safety and organization of the physical environment, and the children's visible comfort levels within each household. The investigation then extends into collateral contacts, where the evaluator interviews the children's teachers, school counselors, primary pediatricians, and long-term neighbors to gather objective, third-party data regarding the parents' real-world performance. Simultaneously, the court may appoint a guardian ad litem, an independent attorney tasked solely with protecting and advocating for the legal and personal interests of the minor children during the litigation. The guardian ad litem conducts separate interviews with the family and files a formal report detailing what specific custody arrangement will best shield the children from parental conflict and support their psychological development. Family law judges historically place immense weight on the final written recommendations submitted by custody evaluators and guardians ad litem, routinely adopting their proposed parenting plans as the permanent, legally binding order of the court. Once the physical parenting schedule is established, the exact number of overnights assigned to each parent is used to calculate child support obligations. The majority of United States jurisdictions in 2026 utilize the income shares model to determine support transfers. This economic model operates on the principle that a child should receive the exact same proportion of parental income that they would have received if the family unit had remained intact. The automated state calculator combines the gross monthly incomes of both parents, applies standardized deductions to arrive at a net disposable income figure, and cross-references this total with the state-mandated basic child support obligation table to establish the baseline cost of raising the children. This baseline cost is then split proportionally between the parents based on their respective incomes. However, the physical timeshare percentage acts as a major modifier. In a true joint physical custody arrangement where the children spend exactly 182 overnights per year with each parent, the higher-earning parent will still pay child support, but the transfer amount is heavily mitigated to reflect the reality that both households are directly absorbing the daily operational costs of housing, feeding, and clothing the children. If Christopher's timeshare drops below a specific statutory threshold, his child support obligation escalates dramatically, requiring him to make substantial monthly financial transfers to the primary household to balance the perceived standard of living between the two domestic spheres. Beyond the baseline child support transfer, the court issues separate orders governing mandatory add-on expenses. These expenses are typically split proportionally according to income and encompass the costs of work-related childcare, medical insurance premiums, and all unreimbursed healthcare expenditures. Case studies in high-conflict dynamics show that contentious arguments frequently erupt over discretionary add-ons, such as private school tuition, elite club sports fees, and summer camp enrollments. If the final judgment does not explicitly detail the exact mechanism for requesting, approving, and reimbursing these expenses, the parties regularly find themselves trapped in a continuous cycle of post-judgment modification litigation. The finalization of the parental custody and support orders successfully establishes the permanent operational framework for the children's lives, drawing rigid boundaries around parenting time and financial contributions. Yet, as this legal and parental structure solidifies, a separate, deeply destabilizing transformation begins to accelerate outside the courtroom. The division of the household and the reconfiguration of parental roles inevitably forces a massive realignment of the couple's broader social environment. How do social circles, long-term friendships, and extended family networks fundamentally fracture when a marriage dissolves? What occurs when the private reality of a marital separation spills entirely into the public domain, forcing individuals to navigate social isolation, shifting community allegiances, and the complex process of rebuilding a completely independent public identity? In the next part of this deep dive masterclass, we will step away from judicial orders and custody matrices to analyze the hidden dynamics of the community divorce, exploring the systemic social restructuring that occurs as the individual attempts to forge a new life within their civic and social spheres. The community divorce functions as the public reconfiguration of an individual's external social architecture, representing the precise point where the private collapse of the marriage spills irreversibly into the public domain. Academically, this phase is characterized by the systemic fracturing of shared social networks, the depletion of accumulated social capital, and the forced realignment of community allegiances. Sociological research into network density demonstrates that long-term married couples typically share upwards of 70% of their active social nodes, meaning their friendships, civic associations, and community interactions are deeply intertwined. When the legal and financial mechanisms split the primary domestic unit, an immediate destabilizing pressure is applied to this shared social matrix, forcing friends, neighbors, and institutions to navigate a complex landscape of divided loyalty and structural polarization. Imagine a scenario unfolding in the current social landscape of 2026. Consider a project manager named Brian, who has resided in a tightly knit suburban community in North Carolina for over 12 years. Throughout his marriage, Brian's entire social existence was anchored to a shared network composed of neighborhood couples, youth sports associations, and local civic groups. The moment the formal separation becomes public knowledge, the community divorce triggers a series of social realignments. Friendships that were once fluid and natural suddenly become awkward, guarded, and highly transactional. Brian quickly observes a phenomenon known as social tribalization, where the shared network begins to unconsciously segregate. Friends feel an intense, unspoken pressure to choose sides, frequently aligning with the spouse they perceive as the aggrieved party or the individual with whom they had the deeper historical connection prior to the marriage. This polarization is rarely malicious. Rather, Historical trends in behavioral sociology indicate it is a defensive mechanism against social discomfort. Shared acquaintances often lack the emotional vocabulary or the psychological capacity to navigate the ambiguous grief of a dissolving couple. As a potential outcome, they react by withdrawing entirely, enacting a policy of social avoidance that leaves both Brian and his former spouse facing an acute, unexpected sense of social isolation. Invitations to group gatherings, dinner parties, and seasonal community events systematically dry up. The couple, once viewed as a singular, predictable social anchor within the community, is now viewed as a source of volatile social tension. In the contemporary landscape of 2026, this physical isolation is drastically amplified by the digital architecture of modern life. The digital community divorce introduces a highly invasive layer of public scrutiny. The second relationship statuses are modified, or when the shared digital footprint begins to diverge through the deletion of photographs and the uncoupling of online profiles, predictive algorithms instantly accelerate the social divide. Platforms begin segregating digital networks, altering feed preferences, and filtering out mutual connections. Brian experiences algorithmic isolation, where the digital infrastructure automatically curtails his visibility within his old community spaces. Furthermore, the modern expectation of constant digital transparency turns personal choices into matters of public evaluation. Every post, location tag, or visible connection is analyzed by the broader social circle for hidden meaning, turning the digital space into a psychological minefield where a single misstep can permanently alienate lingering community support. Beyond casual friendships, the community divorce inflicts severe structural damage on the extended family network. In-law relationships that were nurtured and solidified over decades can vanish with astonishing speed. Grandparents, aunts, uncles, and cousins who once formed a cohesive, unified support system for the household are suddenly recategorized as adversarial entities. Case studies in family systems theory show that extended families naturally rally around their biological or primary relative, absorbing the defensive postures and narrative biases of that individual. This severing of the extended family infrastructure is particularly damaging when minor children are involved, as it rapidly shrinks the child's external safety net at the exact moment they require maximum environmental stability. Simultaneously, individuals face the arduous task of navigating institutional spaces where their shared identity was once firmly established. This includes religious congregations, fitness centers, country clubs, and professional associations. In many high-conflict case studies, the logistics of continuing to utilize the same physical spaces become untenable. If Brian and his former spouse both attempt to attend the same local civic meetings or utilize the same community facilities, the potential outcomes include ongoing public confrontation and heightened anxiety. Consequently, one or both parties are routinely forced to concede these spaces, voluntarily abandoning long-term institutional memberships and sacrificing vital components of their personal identity just to avoid perpetual conflict. This represents a massive uncompensated loss of localized social capital that requires years of deliberate effort to rebuild. The final and perhaps most exhausting component of the community divorce is the mandatory construction of a sovereign public identity. For years, the individual was perceived by society through the collective lens of a marital partnership. Every introduction, professional networking event, and casual interaction was framed by that shared status. Forcing a transition from a shared identity to an autonomous, singular identity requires a profound cognitive and behavioral shift. The individual must learn to navigate the public sphere as an independent economic and social agent, learning to present their new reality to the world without shame, defensiveness, or over-explanation. This public realignment marks the definitive conclusion of the external divorce journey. The legal system has adjudicated the asset division, the parental rights have been structurally allocated, and the social matrix has been thoroughly dismantled and reassembled. The external world now recognizes the individual as entirely separate. Yet, as the noise of the courtroom fades and the social dust finally settles, the individual is forced to confront the final, ultimate station of the entire dissolution life cycle. The external separation is complete, but the internal world remains profoundly fractured, trapped in the emotional debris of the dead relationship. How does an individual successfully execute the final, most elusive phase of the entire matrix, known academically as the psychic divorce? What are the precise psychological milestones required to completely dismantle the internalized emotional ghost of the former spouse, dissolve the lingering bonds of systemic resentment, and successfully reclaim absolute cognitive sovereignty over one's future. In the 10th and final part of this deep dive masterclass, we will step entirely away from the external world and venture deep into the internal landscape of psychological recovery, mapping out the scientific stages of ultimate emotional closure and the complete resolution of the self. The psychic divorce represents the absolute climax and arguably the most arduous station within Bohannon's structural matrix. It is the internal cognitive uncoupling that must occur long after the civil court decrees are signed, the marital assets are distributed, and the social networks are permanently reconfigured. Academically, the psychic divorce is defined as the systematic process of reclaiming individual autonomy, developing a completely sovereign self-concept, and entirely dissolving the internalized emotional presence and influence of the former spouse. In many historical trends and psychological case studies, individuals remain legally and financially separated for years while remaining deeply psychically married, continuously bound by destructive loops of resentment, unmediated anger, or an idealized nostalgia for a domestic past that no longer exists. Imagine a scenario unfolding in the current psychological and social landscape of 2026. Consider an educational administrator named Taylor, residing in Denver, Colorado. Taylor's final judgment of dissolution was officially entered by the family court over 12 months ago. On paper, the economic divorce is entirely finalized, the co-parental schedule is functional, and the community network has been thoroughly navigated. Yet, Taylor's internal architecture remains profoundly tethered to the trauma of the old relationship. Every major life decision Taylor makes, from selecting a new career path to planning personal expenditures, is still subconsciously processed through an invisible, highly reactive cognitive filter, evaluating how the former spouse would react, or how a specific choice might prove the former spouse wrong. This internal dynamic represents a severe systemic barrier to authentic psychological recovery, demonstrating that true autonomy is not merely the absence of a legal bond, but the total elimination of an emotional charge associated with that bond. To understand how Taylor can successfully navigate this final stage, we must analyze the specific psychological mechanisms that govern identity reconstruction. During a long-term marriage, an individual's self-concept undergoes a process known as cognitive interdependence, where the boundaries of the self expand to include the traits, preferences, and identity of the partner. The self becomes fundamentally plural. When this structure is forcibly dismantled by a divorce, the sudden removal of the relational partner leaves a massive, destabilizing void in the individual's cognitive map. This often results in a state of identity foreclosure, where the individual experiences severe disorientation, a loss of personal agency, and a profound inability to answer the core question of who they are outside the context of the shattered union. Step by step, the transition into authentic psychic autonomy requires a systematic deconstruction of this relational residue. The first critical phase involves the complete cessation of internal dialogue with the former spouse. Behavioral scientists note that individuals in the wake of a highly adversarial divorce routinely engage in chronic mental rehearsal, staging elaborate imaginary arguments or defending their past actions to an internalized version of their ex-partner. This rumination consumes immense cognitive bandwidth and continuously triggers the body's acute stress responses. To break this maladaptive feedback loop, an individual must actively practice cognitive reframing, consciously shifting their locus of control from an external focus on the ex-spouse's behavior to an internal focus on their own current choices and immediate environment in 2026. The second phase of this internal evolution centers on the deliberate reclamation of personal space and individual values. Case studies in post-divorce behavioral adaptation show that successful recovery is highly dependent on an individual's willingness to engage in new, independent activities that possess zero historical connection to the marriage. Taylor must systematically audit their personal preferences, separate their authentic desires from the compromised choices made during the marriage, and actively construct a new daily routine. This involves establishing independent financial goals, exploring unique intellectual interests, and redecorating or relocating their physical living environment to ensure it reflects their sovereign identity rather than a shared past. Through continuous habituation, the brain builds new neural pathways that decouple daily experiences from the memory of the marital unit, gradually reducing the frequency and intensity of emotional triggers. Furthermore, achieving a successful psychic divorce requires a profound shift in how an individual conceptualizes the history of the marriage itself. In the immediate aftermath of a dissolution, the prevailing narrative is often dominated by blame, victimhood, and a sense of systemic failure. While these emotions are natural responses to acute trauma, Maintaining a rigid narrative of victimization indefinitely prevents the individual from achieving emotional closure. Historical trends in trauma recovery indicate that true psychological integration occurs when the individual transitions from an adversarial narrative to a systemic narrative. This means Taylor must reach a point of objective clarity where they can view the marriage and its subsequent demise not as an unmitigated catastrophe or a personal indictment, but as a complex historical chapter in their life story. A chapter that has concluded, offering vital data for personal growth, but one that no longer defines their current worth or limits their potential outcomes. This psychological neutrality is especially critical when navigating long-term co-parenting relationships. If a parent has not achieved a psychic divorce, every routine interaction regarding childcare schedules, medical appointments, or educational expenses becomes a battleground for unresolved marital conflicts. The parent will misinterpret administrative logistical adjustments as personal attacks or deliberate provocations. Once the psychic divorce is fully realized, however, the communication dynamic transforms entirely. The ex-spouse is no longer viewed through the emotionally charged lens of a former romantic partner or an intimate adversary. Instead, they are treated with the cool, detached professionalism of a business associate. The relationship is strictly recategorized as a joint venture dedicated to the successful raising of the children, effectively shielding the next generation from the toxic fallout of historical parental discord. The ultimate metric of a completed psychic divorce is not hatred or active animosity, but a profound, sustained indifference. Hatred is a highly energetic emotional state that requires continuous psychological investment, meaning that as long as an individual hates their former spouse, they remain deeply connected to them. Indifference, however, signals that the emotional cords have been completely severed. The ex-spouse no longer possesses the capacity to disrupt the individual's internal peace or dictate their behavioral choices. Taylor reaches a state of cognitive sovereignty where the memories of the past can coexist with the reality of the present without generating a disruptive emotional storm. The individual is finally completely free. This internal liberation marks the absolute end of the multidimensional life cycle of the American divorce journey. We have systematically mapped every phase of this profound institutional transition, moving step by step from the early, silent phases of emotional alienation and structural erosion, through the high-stakes battlegrounds of civil filings, automatic temporary restraining orders, and pendant light relief. We analyze the exhausting investigative rigors of formal discovery, forensic accounting, and oral depositions, before deconstructing the highly technical legal frameworks of asset characterization, community property apportionment, and business valuation models. Finally, we explored the structural reconfigurations of the economic, co-parental, and community divorces, tracing the entire path from the division of corporate wealth to the final, quiet sanctuary of internal psychological resolution. But while the individual journey through the standard divorce life cycle may reach its natural conclusion here, the broader landscape of modern family dynamics, estate fortification, and the long-term socio-economic trajectories of decoupled households continues to evolve at an unprecedented pace in our contemporary world. The structural choices made at the end of this journey inevitably lay the absolute foundation for the next major epoch of an individual's personal and financial existence. In our upcoming masterclass series, we will pivot our analytical lens away from the mechanics of dissolution to explore the high-stakes, highly strategic frontier of post-divorce wealth architecture, asset protection strategies for solo high-net-worth individuals, and the complex psychological frameworks required to successfully construct blameless, high-functioning blended families in the modern United States.